All right, welcome everyone to the third video in our Pro video series. This is entitled The Secret Power of the FCRA, How to Fight Back. As always, I'm your course instructor, attorney Aaron Swift, the CEO and managing partner of Swift Law North, LLC. You might remember a few videos back, we talked about the secret power of the FDCPA and how to fight back. Now we're talking about the Fair Credit Reporting Act. Much as the same agenda. We're talking about the purpose and power. We've talked about the purpose in past videos, kind of the who, what, and why. Major protections, the damages and remedies available, how attorneys' fees and costs are paid in more detail, and then again, ending with consumer best practices. Okay, so the purpose and power. The purpose governs access to consumer credit reports, promotes accuracy, fairness, and privacy. We've talked about that. Can't stress enough. Think about the title itself. It's the Fair Credit Reporting Act. Congress could have called it the Credit Reporting Act. They didn't. So you always look through the angle of fairness. The FCRA can be is often used to fight back against collection lawsuits, just like the FDCPA, and can spur a lot of debt forgiveness and trade line deletions. Excuse me. And then, litigation via the FCRA is often the only way to spur change in credit repair, because ultimately, if credit repair practices aren't successful, even if they should be, the most objective error may ultimately get verified even multiple times. Then sometimes litigation under the FCRA is your only option. All right, so what are the major protections? We talked about this before. It requires reasonable procedures to assure the maximum possible accuracy. Can't stress that enough, the maximum possible accuracy of information. Now, it doesn't mean everything has to be 100% accurate, but it means you have to have reasonable procedures to try to get to 100% accuracy, and that's kind of the problem. It limits how long bad information or derogatory information can be reported. Most bad info is 7 years. Bankruptcies are 10 years. There's some other variations in there. It provides for a standardized credit reporting and disputing system. We'll get into that in more detail later. And then it regulates access to credit reports via permissible purposes, which are generally a court order, subpoena, debt collection, written agreement with the consumer, and some other instances. Okay, so what are the damages and remedies available under the Fair Credit Reporting Act, the FCRA? Well, first of all, there's also a statutory damage available, but this time it's not 0 to 1,000, it's between 100 and 1,000. The other interesting thing about the FCRA is it's per violation. That's different under the FDCPA, which is per action. Much like the FDCPA, you can get, and the consumer can get, actual damages. Those can be in the form of true monetary loss. Like, for example, if someone's paying a higher interest rate due to errors in their credit report, we can generally calculate how much more they're paying over the life of a loan with a quick amortization schedule, and that can be calculated in terms of an actual damage. You can also, just like the FDCPA, get non-economic actual damages for stress and fear and anxiety. And a lot of times these types of damages drive the bus with these cases because they can be quite significant. If you remember back, well, two important things. Unlike the FDCPA, yes, you can get punitive damages under the Fair Credit Reporting Act, but you have to go back to the different standards that we learned, and you should all know by now from previous videos. There are two types of violations when we're talking about willfulness or negligence. So you can have a negligent violation and you can have a willful violation. For punitive damages to be available, you have to prove a willful violation. So that's a big reason why, again, we talk about amazing case examples in the next video, we still break them up into bronze, silver, and gold. And it's going to be the gold cases where punitive damages are going to be available. So as I mentioned before, it's very often that in addition to these types of damages, we get debt forgiveness and debt waiver, trade line deletion, and the permanency of a settlement agreement. Same question I get all the time about FDCPA lawsuits when someone's been harassed by a debt collector. I get questioned all the time, how can consumers afford to file these lawsuits? We're fighting billion-dollar companies. These debt buyers are huge. These credit reporting agencies are huge. These furnishing banks are, ginormous, the biggest companies we have. So how can consumers afford them? Well, it's the same way they can afford FDCPA lawsuits. The FCRA is, for all intents and purposes, another one-way fee provision where the bad guys pay the attorney's fees of the consumer if the consumer prevails. And if the consumer loses, the consumer, in almost every case, does not pay the defensive fees. That's unless case is brought bad faith or for purposes of harassment, which are, of course, never going to be the cases that we bring. Similar to how we handle FDCPA cases, this is a blended contingency fee agreement where we're paid the higher of our hourly rates or percentage. Again, just depends on where in the case, the type of case, and ultimately how much the defendant fights, which is the same type of incredible leverage where the whole time of a FCRA case, just like FDCPA, the defendant has to be paying their lawyers who charge a lot of money. They hire, some of the best firms in the best, biggest cities, but also have the potential, staring at it, like I called it, the double barrel, because if and when the consumer prevails via settlement, jury verdict, judgment, then the defendants have to pay the consumer's fees. So that gives a lot of leverage as these cases go on. So, what are the best practices? I can't stress this enough. Just know that you have rights, and understanding them provides really an advantage with dealing with errors on credit reports. Don't bury your head in the sand. Check your credit reports, your own consumer disclosures often. Check them against debt collection efforts. And then if you see some errors, reach out. The power of this law is real. It can get significant damages, gets a lot of credit deletions, a lot of credit issues fixed up, cleared, which help, consumers move on with their financial lives. So at, little risk, there's really not much to lose by reaching out because again, the one-way fee provision gives a lot of power and leverage to the consumer. For more information, including how to dispute coming up later in this video series, visit consumerlaw101.com. If you have litigation issues you think out the bat, visit us at swiftlawnorth.com. Thank you.